Okay.
Okay, thank you. Welcome to those in attendance at this remote meeting of the local review body of Aberdeen City Council. Please note that this meeting will be recorded and published online for public access after the meeting. You are also reminded to note that we may have members of the public or press observing today's proceedings. Can I ask those who are observing today's meeting to keep their microphones and cameras switched off throughout? Can members of the local review body leave their cameras on but mute their microphone when not speaking? As the local review body contains quasi-judicial business, members are reminded that should not leave the meeting during the consideration of any of the reviews. This meeting has been convened in response to one request for review for a decision taken by the appointed officer under the council scheme of delegation. Members of the local review body have before them copies of the review documents as listed in the notice calling the meeting. I will now ask Ms McBain, the Assistant Clerk, to outline the procedures to be followed in the conduct of the review and to take a roll call of members present. Ms McBain.
Thank you, Convener. I'll just quickly run through the membership. So Councillor McRae, you're here. Councillor Clark. Councillor Cook.
I'm here.
Yep, I'm here too.
And Councillor Copeland.
Present.
And Councillor Farker.
Yeah, here.
Okay, so that's the 5 members. I'll just read out this statement now. So members have the procedure note which was circulated with the meeting papers and is intended to set out the wider framework within which the review process operates. From this, it is clear that the first task for the review body is to come to a decision on whether the review documents contain sufficient information for the case to be determined without further procedure, and by that it is meant without further information or representations. To assist, I feel it would be helpful to mention the following. Firstly, that the regulations governing the LRB process require that all matters which the applicant intends to raise in the review must be set out in or accompany the notice of review. Secondly, that the focus of the review should be on the basis of what was before the appointed officer when a decision was made, and only in exceptional circumstances will new or additional matters be permitted to be taken into account. Thirdly, to note that the modernisation of the planning system, which included revisal of the planning appeals process, of which this local review body is part, removed the previous right on the part of an applicant to insist on a hearing and replaced that with the LRB, providing them with the power to choose a procedure which more accurately reflects the facts and circumstances of the individual case. And lastly, that guidance issued by the Scottish Government's Chief Planner in 2011 stated that reviews by LRBs should be conducted by means of full consideration of the application afresh. This review should take the form of a structured discussion led by the chairperson to consider the matter set out in the notice of review before you, and I would conclude by drawing your attention to points 10 to 12 of the procedure note. Thank you.
Thank you. Okay, now turn to the consideration of the review in respect of the decision to refuse the application for formation of decking to the front retrospectively at Craigbank 132 North Eastside Road, planning application 221543. We will now hear from the planning advisor in attendance, Ms Lucy Green, who will provide us with a brief description of the planning proposal and a reminder of the reasons why the application was refused. I would point out that Ms Green attends today's meeting to provide us with the necessary professional planning guidance because she's not been involved in the earlier consideration of the application under review. Ms Green will not, however, be able to express any view on the merits of the proposed development, and in effect her role will be a neutral one involving the provision of factual information and guidance only. Ms Green, over to you.
Thank you. Good afternoon, councillors. I'll just share my screen. Okay, so this case relates to the request for review against refusal of an application under delegated powers for the formation of decking to the front of the property at Craigbank 132 North Deeside Road. And the review was submitted with all the necessary information within the time limit of 3 months following the decision of the appointed officer. The applicant indicated on the notice of review that no new matters had been raised in the review submissions. However, it's noted that the statement of support refers to a new matter, which I'll mention later in the presentation, and I'll come back to that for members to decide whether they wish to take that into account. In terms of the procedure by which the review will be conducted, the applicant has expressed the view that a site visit should take place in order to fully consider the proximity to the road and poor visibility, and the review should not proceed based on the information submitted. So I will continue to provide some background to the case before handing back for members to discuss the case and decide how to proceed. So this shows the location of the decking, and it consists, the application site consists of land that relates to the ground floor flat in a granite 2-storey building, which is shared with 134 North Deeside Road, which is the flat above. Site sits within a designated neighbourhood centre in terms of local development plan zoning. And the flat has a south-facing main elevation that fronts onto and is set back from North Deeside Road. So there's about 15.7 metres from the back of pavement to the front edge of the decking. To the west sits the Cooter Parish Church, which is Category C listed, and the existing driveway is shared by 132 and 134 North Deeside Road and extends from the road around to the rear of the building. And the driveway has a length of approximately 17 metres. The case officer's report notes that prior to the decking, there was a section of driveway sitting to the front of the property, and that area measured approximately 5.3 metres in width, and that's under the ownership of the applicant. There was also a recent planning permission granted for a garage sitting on the west boundary of the site on the existing shared driveway, and that was in this location here. I'll just move on to the aerial photo of the property. It's just here is this half, and the decking is located here. So I have a few photographs now. This is just from Street View and it's dated April this year. So you can see the decking there at the front. Another Street View image just slightly further to the east. You can just see a slightly more detailed plan showing the decking in front of the property, and it is a retrospective planning permission. So the decking itself measures approximately 4.8 metres by 4.8 metres, and it's approximately 500 mil in height from ground level. The decking has also been fitted with 8 timber posts which are connected with rope, and they give an overall height of 1.5 metres. And the decking is finished in an untreated light timber. Further plans show existing and proposed. Obviously the decking's actually there on site, and you can see the timber posts around the edge there. And that's the front door to the applicant's property. And that's the elevation just shown in relation to the plan. And the west elevation. The east elevation. You can just see the heights indicated there. So overall 470 mil in height is indicated there. The applicant also submitted these diagrams that show how vehicles could turn on the driveway. So this is a large car tracking, showing how it could turn at the back of the property, and then a standard car. And the applicant also owns the garage here. This is a photograph submitted by the applicant just showing planting that exists in front of the decking. Further photograph from the applicant, which is described as showing a work van obstructing the view of vehicles that preventing them pulling out safely onto North Deeside Road. And this is the detail of the laurel hedging, which the applicant states will look like the picture within a year, so that no one would be able to see through it. These are a few photographs taken by the case officer, which are on file from the east there. Slightly further round. Again from the east, from within the property. And looking from the end of the drive onto North Deeside Road. And again. So in terms of the reason for refusal, I've just put that in full on the slide. It relates to the siting scale and design of the proposed decking not being acceptable because it's forward of the principal elevation of the building, not compatible with the form and layout of the existing building, as it appears as a separation from the building and unbalances the appearance of the front elevation. Also appears prominent from the public road as it sits at approximately at eye level above the existing boundary wall, having an adverse impact on the appearance of the existing street scene and visual amenity of the surrounding area. The reason states that proposal would not result in a significant change to parking facilities on the site. There'd be one parking space still available, and that the proposal overall would not comply with policy H1 residential areas, policy D1 on design, and the supplementary guidance, the householder development guide, and also relevant policies of the proposed, well, at that time, the proposed local development plan, obviously since has been adopted as the 2023 local development plan. Finally, it states that the proposal is also considered acceptable against relevant policies in the National Planning Framework 4. So just moving on to the applicant's case. The applicant considered that all information had not been taken into account, including the visibility splays, which were the ones that I showed you on a previous slide. They query an objection from a DICE address while stating that the church supports the application. They state that the decking is not too high as it's less than 50 centimetres above ground level. Query whether the appropriate policies have been used, and that seems to relate to the adopted plan at that time, the 2017 plan, versus the current 2023 plan. They describe ownership issues on the site and surrounding area. They state that businesses nearby have outdoor seating areas and that the elevation of the decking is required because it sits on sloping ground. There was one representation had been received objecting to the proposal, stating that it was not consistent with policies H1 for residential areas and D1 design in the local development plan due to its prominent location adjacent to the listed Cooter Parish Church and also its impact on the street scene. Secondly, that it didn't comply with the householder development guide, stating that there's a presumption against the formation of decking to the front of any property. So the new information that I mentioned previously is that the applicant has submitted a statement of support from councillors Bolton and Massey, and I'll just hand over to legal advisor Elena Plews to cover this matter.
Thank you, Ms Green. As Ms Green has highlighted, a new matter has been raised, and there are certain restrictions relating to certain new matters being raised in a local review body hearing. This is a reminder for the review body of the test which is set out in the legislation. In order for the LRB to be satisfied that the new matters can be taken into account, they need to be satisfied that the party has demonstrated that the matter in question could not have been raised before that time, or that it not being raised before that time was a consequence of exceptional circumstances. However, that does not affect any requirement or entitlement for the LRB to have regard to, first of all, the provisions of the development plan or any other material consideration. I'm happy to take any questions on that point, convener. Otherwise, I'll pass back to Ms Green.
Thank you. Do any members have any questions on the new information letter received from the two councillors?
I have. Yeah, thank you. Can you tell us when the new material was received in relation to the original application?
I can confirm that it was received with the local review application, so in June, with the rest of the documents for the local review.
Right, thank you.
Any other questions from members for legal? John, Councillor Cook, go ahead.
Thanks. Yeah, it was on the sorry, late representation, because I can recall that we had another LRB that was in the West End in my ward, and all four councillors wrote in support of the application. And I think at that one we were told it's too late, you can't put it in. So have we got a kind of track record of how we are dealing with these, or can we do it on a case-by-case basis?
I think, Councillor Cook, we deal with things on a case-by-case basis. Obviously, this matter is now at the local review body, and this letter has been submitted as part of that process. And it's now up to the review body whether or not this new matter is taken into consideration or not. You might consider that it's a new matter that is appropriate to be taken into consideration now because it was written as a direct response to the refusal of the application, as opposed to in advance of that, because it hadn't been refused, and therefore perhaps the councillors didn't feel that there was anything to do at that point. Or you may feel that it shouldn't be taken into consideration because they could have written in advance of the determination. But it's really a matter for the review body to weigh up. But yes, it's a case-by-case situation.
Thanks, that's helpful.
Okay, so we'll move on to the question for the members of the LRB. Is the LRB satisfied that the new matters raised in the notice of review should be taken into account in this review? My opinion is that this is a written response in regards to the review to the LRB. I don't know how other members are minded, so I'll just go around the room. Councillor Cook.
I don't object to taking it into account, to be honest. I'm comfortable with it.
Okay, Councillor Clark.
Likewise, I'm comfortable with it.
Councillor Copeland.
Yeah, no problems for me.
And Councillor Thacker.
Yeah, likewise, I'd like to consider it.
Okay, therefore the LRB members have accepted the new information.
So at that point, I would hand back to you anyway, convener, to decide how you wish to proceed. Obviously, the applicant has requested a site visit, So I'll hand back to you on that.
Thank you. I think in light of the information that we received up to now, as well as the additional photographs that have been shown by yourself, I am content to proceed at this point. I'll just go around the room again. Councillor Cook.
Yeah, I'm also content to proceed at this point.
Thank you. Councillor Clark.
I'm content to proceed.
Thank you. Councillor Copeland.
Yes, I'm happy to proceed without the site visit.
And Councillor Thacker.
Yeah, likewise, happy to proceed.
Okay, I think I go back to you now, Ms. Green.
Yes, I'll just share my slides again. So turning to the relevant policies, first of all, the National Planning Framework 4, which consists of national policies which form part of the development plan. A number of policies are relevant. Policies 1 and 2 are overarching and relevant to almost every application, whilst this is, obviously a small-scale householder proposal. Policy 7 on historic assets seeks to protect the setting of listed buildings. Policy 14 on design, similar to policies on design in the adopted plan, which I'll cover in a moment. And policy 16 relates to high quality homes, and I'll just cover that in the next slide. So this is policy 16, which states householder development proposals will be supported where they don't have a detrimental impact on the character and environmental quality of the home and surrounding area in terms of size, design and materials. And secondly, that they don't have a detrimental impact on neighbouring properties in terms of overshadowing and overlooking or physical impact. And then there's policy 14 on design, which just states that proposals will be designed to improve the quality of the area, regardless of scale. So moving on to policies in the Local Development Plan 2023, which would now be used as the basis for the decision. So obviously the decision on the application was taken before this plan was adopted, so it quoted policies from the 2017 plan. But we're now that we have the adopted plan, these are the relevant policies. So policy VC8 is not particularly relevant as it relates to retail uses within the neighbourhood centre, whereas this is a householder development. The householder guide advises that matters such as siting, scale and design are relevant, and both this and the managing change guide suggest that the decking should be considered in relation to the surrounding context, which in this case includes the category C church to the west. Policy D2 on amenity requires consideration. Well, it covers a number of matters, but most relevant to this is that it requires consideration to be given to the need for outdoor areas for residents, although it usually relates to new residential accommodation. Parking policy T3 points towards the parking standards in the planning guide on transportation, and as noted in the report, the standard for flats is 1.5 spaces. So just looking at the householder guide in a bit more detail, in terms of decking, it states that proposals shouldn't result in an adverse impact on the amenity of adjacent dwellings, including their internal accommodation and also their external private amenity space. And then secondly, there'll be a presumption against the formation of decking to the front of properties or on any other prominent elevation where the works would adversely affect visual amenity of the street scene. In terms of design, policy D1 in the plan seeks to ensure high standards of design for development with a strong and distinctive sense of place, considered as within context, including looking at quality architecture, craftsmanship and materials complementing the building. And in assessing design, it's important to take into account the context. And the policy also recognises that not all development will be of a scale that makes a significant placemaking impact, but recognises that good design and detail adds to the overall attractiveness of the built environment. So overall, evaluation of the application should be on the basis of the development plan, which is the National Planning Framework and the Local Development Plan, and that all applications be determined in accordance with the development plan unless material considerations indicate otherwise, with obviously each application treated on merit. So the basis for the decision in this particular case would be consideration of how the proposal would affect the character and amenity of the area, and would it comply with the householder guidance on decking? And secondly, would there be an acceptable impact on the setting of the listed church? So overall, does it comply with the development plan as a whole, or are there material considerations that would weigh for or against the proposal? Thank you, and I'm happy to answer any questions.
Thank you, Ms. Green. Do any members have any questions or points of clarification on the information received? Councillor Cook.
Thanks. Thanks, Claire. Could you just, Ms. Green, clarify the issue on the presumption against decking to the front of a property? Presumption against is not an absolute 100% barrier. It's a presumption, but you could depart from that if there were other reasons. Is that right?
Yes, that refers to the householder guide. So obviously that's the general guidance, and you would take into account the particular merits of the site.
Thanks for that.
Thank you, Councillor Cook. Any further questions? Yep. Councillor Copeland.
Yeah, thought you can read out. Ms. Green, just confirm the intention is to put a hedge or something like a hedge across the front of the decking to screen it from the street. Is that right?
Well, you can see that there's been laurel hedging planted already. It's not shown on the application drawings, but it is already in place.
Thank you for that.
Thank you. Any further questions from members? Okay. So at this point, in accordance with the... Oh,
Councillor Cook.
Councillor Cook, go ahead.
Thanks, Davina. Sorry about that. It was great. In the slides that you showed us, there was a thing that the applicant had submitted about how easy or difficult it would be for a car to turn around in the drive. Could you just show us that one again? Sorry, what I'm thinking is that's a pretty busy road, so you wouldn't want people to be backing out onto the road. You'd want them to be going out onto the road forwards. So just trying to see how easy it is to turn around in that driveway.
Yeah, and that's the diagram that I showed you. I guess I would just add to that the case officer took into account that the applicant owns a garage up here, which they could use to turn in. And the other property, I think, owns this section.
Thanks, that's helpful.
Thank you. Any further questions from members? Nope. Final call. Grand. Right, in accordance with the procedural note circulated, the LRB will now discuss and decide the manner in which reviews to proceed. I will highlight that all representations relating to the case have now been considered and taken into account. So we'll now go to any discussion and then we'll move to determination. So at this point, just my tuppence worth, obviously the presumptions against decking to the front in the householder guide there, but I feel that in my opinion the length of the garden to the pavement is substantial enough that it doesn't cause any differences in amenity at that point, and I feel that it's not large enough to have any impacts on the church, to the fact that the church are no representations have come via the church or the community council in that regard. So we're really treating it on its own merits at this time. Although I do agree that applying after the fact isn't brilliant, but we are where we are in this at the moment. Any other councillors have anything to add? Councillor Copeland.
Thanks, Convener. I would tend to agree with you, and also the fact that the neighbours at the other side of the semi haven't lodged any objections as well. I think is very telling, nor has the neighbour above who shares the driveway. I don't like retrospective, but they've obviously been able to make it work for their cars up to now, so I can actually see no reason really to refuse this. Thank you.
Thank you. Anyone else wish to enter? I'm not seeing any hands or indications. Oh, Councillor Cook.
I agree with what you said and what Councillor Copeland said.
Okay, if no one else wishes to enter, we'll now move to determination. So at this point, I would be moving to overturn the officer's recommendations and approve the application. I'll just go around the room. So Councillor Cook.
Yeah, agreed, approve.
Thank you. Councillor Clark.
Totally agree.
Thank you. Councillor Copeland.
Approve.
And Councillor Thacker.
Likewise, agree with approval.
Okay, thank you very much. The local review body has therefore agreed to unanimously overturn the decision of the appointed officer, and therefore the application is approved. Please note that a decision notice from today's meeting will be issued to the participant or agent in the forthcoming days. Thank you very much for your time this morning. Thank you.
Sorry, excuse me, convener.
Oh,
Can
yeah.
I just ask, are there any conditions that the review body would want to put on that, or approval? I'm guessing possibly not, as it's retrospective and there's planting already there, but I just want to be sure about that.
Yeah. Okay. I don't have any comments on conditions. I don't know if any other councillor wants to comment on that.
Yes.
Okay, Councillor Copeland.
Yeah, thank you, Convener. I would want a condition on the screening with the planting. Has to be there. If it's removed, then it's not acceptable. I want the screening as a condition of it.
Are members happy with that condition? Yep, I'm seeing nodding heads. So we'll accept that planning condition on this, that screening must be in place for the decking. Ms. Green.
Yeah, it was just to clarify. Usually what we would say for that sort of landscape planting was that if any of it becomes, dies or becomes removed within the next 5 years, that it would be replaced with something similar. So would that cover what you would like as a condition?
Yeah, I'm seeing nodding heads, and Councillor Copeland's in my ear saying that that's acceptable to him as well. So I'm happy to go with that. Okay, and I think that draws this meeting to a close. Thank you very much for your time this afternoon. Thank you.
Thanks. Thank you.